Hello everyone, welcome to Steno Aspirants. I am Akshay and I am going to dictate you Rajasthan High Court judgment containing 720 words at the speed of 90 words per minute. The dictation will fluctuate between the speed of 85 to 95 words per minute. So get ready. 3 seconds. Start. It was further held that differential treatment does not per se amount of violation of Article 14 of the Constitution of India, and it violates Article 14 only when there is no reasonable basis. Stop. It was held thus. Stop. Thus, Article 14 in its ambit and sweep involves two facets which it permits reasonable classification, which is founded on intelligible differentia and accommodates the practical needs of the society, and the differentia must have a rational relation to the objects sought to be achieved. Further, it does not allow any kind of arbitrariness and ensures fairness and equality of treatment. Stop. It is the fons juris of our constitution, the fountain head of justice. Stop. Differential treatment does not per se amount to violation of Article 14 of the Constitution, and it violates Article 14 only when there is no reasonable basis, and there are several tests to decide whether a classification is reasonable or not, and one of the tests will be as to whether it is conducive to the functioning of modern society. Stop. Therefore, the action of the respondents in not including the post of steno and assistant in the midday meal scheme for the purposes of grant of bonus marks for working experience is clearly arbitrary, discriminatory, and violative of Articles 14 and 16 of the Constitution of India. Stop. The respondents are directed to accordingly carry out necessary amendment in the rule to remove discrimination by including the post of steno and assistant as well for the purposes of grant of bonus marks for working experience on those posts. Stop. Wide detailed order dated 23/10/2017, this court directed the respondents that length of services rendered by petitioners number 2, 3 and 4 for the post held by them in the midday meal scheme be considered for grant of bonus marks after due verification of their service in terms of proviso to Rule 273 of the Rules of 1996. Stop. Their consideration, however, was made provisional. Stop. It was further directed that if their names find place in the order of merit, they may be considered for appointment, though their selection shall remain subject to final outcome of the petition. Stop. If the petitioners number 2, 3 and 4 have found place in the merit list in compliance of the direction wide order dated 23/10/2017 and thereafter appointed, they shall continue to appointment with all consequential benefits and shall no longer be treated as provisional in nature. Stop. Passage. This criminal appeal is directed against judgment dated 17/12/2008 of learned additional sessions judge fast track number 1 Ajmer in sessions case number 110/2007, whereby accused appellant Mahendra Singh and Godha has been convicted for offence under section 302 of the Indian Penal Code and sentenced to suffer rigorous imprisonment with fine of rupees 1000, and in default he has to further undergo 3 months simple imprisonment stop passage. Briefly stated, the facts of the case are that a first information report number 246/2007 exhibit P1 was registered at police station Christian Ganj, Ajmer on 9/9/2007 by one Sohan Singh, son of Mr. Sakhta Singh, against unknown person, alleging therein that his wife Srimati Geeta went on the mines to work on 8/9/2007 and did not return therefrom till 7 p.m. in the evening stop. It was further alleged in the FIR that when he came to his house, he was told that his wife had gone to search the goat on nearby hills and did not return therefrom stop. Dhara Singh, Jairam, Bhavani went to search her on nearby hills, where they found dead body of deceased Geeta stop. It was further alleged that her wife had died due to the injury of X caused by someone stop. Some more villagers came on the spot and thereafter the FIR was lodged stop. The police commenced investigation and appellant was arrested and a charge sheet under section 302 of the Indian Penal Code was filed by the police against him stop. Since the case was exclusively triable by the Court of Sessions, the same was committed to the Additional Sessions Judge Fast Track number 1 Ajmer stop. The court framed charge under section 302 IPC against the appellant stop. The appellant pleaded not guilty and claimed to be tried stop, while the prosecution examined 24 witnesses in support of its case and produced 50 exhibits. The defense stopped over.